matter to come before the court this morning is in re M.O. Both parties will have 15 minutes to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve any time for rebuttal, if you let me know when you get started. I'm keeping the clock this morning and can keep you apprised of the time remaining. I would caution counsel or remind them that this case has a juvenile involved, and we broadcast our oral arguments on YouTube. So if you could refer to a juvenile by either the child or the initials, that would assist us in keeping with our sensibilities of putting this out there on the internet. We appreciate it. We have read the briefs and we're ready to proceed when you are.
Thank you. May it please the court. My name is Neil Agarwal. I represent the appellant Michael Odo. I will reserve 5 minutes for rebuttal. Your Honor, the facts of the case are not in a huge dispute. Concerning the first assignment of error, the judge granted legal custody to the mother and awarded the magistrate awarded custody after a contested hearing to the mother and awarded father visitation 3 weekends a month. Okay. The judge, there was objections made by the father to the judge, and the judge pretty much upheld the magistrate's ruling, except modified father's visitation from 3 weekends a month to every weekend a month. Father then appealed that ruling to this court. The mother also filed her own cross appeal from the judge's decision. Thereafter, the judge issued a nunc-pro-tunc saying, I didn't mean every weekend for the father, I meant the 3 weekends that the same as the magistrate. Now, and father then reappealed that to this court. As our first assignment of error, under Civil Rule 60A, if there is a nunc-pro-tunc to correct a clerical error, which I'm arguing is not even a clerical error, because it's pretty substantive to change from 3 weekends to go from every weekend down to 3 weekends, it says, however, but whether it's a nunc-pro-tunc is issued during the pendency of an appeal, the mistake of the nunc-pro-tunc so-and-so, once the appeal is docketed, may only be corrected with leave of the appellate court. This court did not get a request from the judge, from the father, from the mother, from the guardian, from the CSP prosecutor. Nobody came to this court requesting leave to issue a nunc-pro-tunc. Therefore, this court has already previously held in other cases, Evanovich versus Bridge, Naples versus Naples, that once an appeal is docketed, the trial court cannot correct its journal entry. That is the purpose of the appeal. And in fact, mother filed a cross appeal. But they have raised no assignment of error on their appeal, so in effect, they're saying we're okay with the original trial court's ruling. The modification of the nunc-pro-tunc we're arguing is defective and void because there's no leave of this court. Concerning the second and third assignment of errors, they really go hand in hand. The magistrate, when she issued a ruling after the conclusion of the legal custody hearing, she awarded child support to be paid, and she ordered that the parents would comply with the prior divorce decree between them concerning the Stark County parenting time schedule. And to the magistrate's credit, she included a copy of the Stark County parenting schedule to its journal entry, saying this is what I'm talking about when I say Stark County, and here's the child support calculation of how I came to the figures of the child support. Well, after objections were made to the judge, and this is on Appendix A14, the judge just simply said, and I quote, the parents shall abide by the Stark County Court parenting time schedule. And that's it. It doesn't say it's attached. It doesn't say, as attached to my journal entry. She doesn't say as incorporated by the magistrate's decision. There is nothing to reference what the judge meant when she said you have to follow the Stark County Court parenting time schedule.
Well, it says attached as addendum A.
No, that is the magistrate's decision.
No, it's on the judgment.
I'm looking on A14, Your Honor.
I'm looking at May 16, 2016, entry signed by Judge Linda Tucci. This says right there, order number 4.
That is correct, Your Honor, but that is an interim order. That was, see what happens when the magistrate issues a journal entry, the judge issues a immediate journal entry with it. But that's an interim order, and then once there's objections made, she has to issue a final order.
You're talking about the August 17th.
Correct.
Okay.
I'm now talking about, see, when the magistrate makes a ruling, the judge immediately incorporates it. She basically just rubber stamps it and creates it and says all that. Once there's objections made, then she has to independently create and make her own journal entry based upon the facts and the
But
arguments.
you're saying then they have to reiterate everything that was in the original order?
Well, she, at that point, is to take a fresh look at what the magistrate
I
did.
understand, but I think our case law says they have to rule on the objections, right?
Yeah, they do. But again, if she's saying you have to follow the parenting schedule, well, what is she referring to?
Well, but that's my point. What I'm asking you is, it's your position then, that they not only have to rule on the objections, but they have to say everything that was in the prior interim order.
Assuming that she agrees with her prior interim order. Yes.
Well, she does in number 3 of that August order. It says, shall abide by the start time, film, court, running time schedule.
That's what it's, no, and I
It
agree.
just needs, it needs to say attached as addendum something.
Correct.
That's what you're saying.
Right, because
It's missing some words.
it is. It has to say one of two things.
Right.
It says, shall abide by the Stark County parenting time schedule as attached, as Exhibit A,
Right.
or as referenced in the magistrate's, whatever. But I would actually argue that's not defective. That's defective. It really has to be attached, because when you look at a judge's final ruling, all rights and obligations has to be contained in the 4 corners of that document. And I'm saying that did not happen here. She's referring to a schedule that she didn't attach or incorporate in her final ruling, and saying with the child support calculations. And here under order number 4, and this is on A14, father shall pay $240 and 0 for cash medical support. But where is the child support calculations she came up with to rule on? Now again, the magistrate included it, incorporated, and said it's attached. But when the judge ruled on the final objection, she did not incorporate. This court is...
Counsel, if you don't care, let me interrupt you just for a second.
Yes.
I apologize, but it seems to me like you're making an FAO issue. A final appealable order issue. It sounds like you're raising a final appealable order issue because you're saying that the final document, we call it the final appealable order, doesn't lay out all the rights of the parties.
Yeah, I would argue that. I would agree, Your Honor, but again, if I don't appeal, I can never get a ruling from the trial judge. But yeah, I would agree, if you don't incorporate, well, you could argue it one of 2 ways. It's defective because you didn't include the child support calculation, or in the alternative, it's not a final appealable order because it didn't include the child support. Either way, it has to be reversed and remanded. So I would agree, Your Honor, that I'm not sure it's a final appealable order, but she's referencing a parenting time schedule she didn't incorporate or include, and same with the child support calculation. Now, most importantly, assignment of error number 4, father argued that because the parties were previously married and divorced, and that there was a order from the domestic court that awarded father legal custody and awarded the mother visitation, that a shared parenting plan, that has to be considered at the end of an abuse, dependency, neglect for a final disposition under 3109.04E. Father argued E1 applied, mother argued E2 should apply in the determination of allocation of the parental rights. The judge, and I'm quoting on page A10, the very last sentence, this is from the judge in her August 17th ruling. The court finds that the applicable law is 2151-353, which sets forth the order of disposition of abused, neglected, or dependent children. So she's saying, I am not going to consider the domestic statute under 3109.04 in determining what is the best interest, change of circumstances, so on and so forth. However, the Ohio Supreme Court specifically held in re-polling that when there is an abuse, dependency, neglect case, you have to still consider the domestic statute when there was a prior allocation of parental allocation of parental rights. That decision has never been overruled or superseded as far as I can tell. And further, this court held it, and this is on page 12, top paragraph, that this court held it in re Shordell, 1999 Westlaw 312380, that a court's mere recitation of findings with no reference to supporting facts is insufficient to rise to the level of credible evidence for the mandatory elements under 3109.04E. So here, the trial court specifically said, I am not going to consider 3109E. It was not incorporated, it was never referenced, it was never mentioned, and that is reversible error. So, in respect, Your Honor, I would ask the court to reverse and remand for further proceedings and reserve the balance of my time.
Hello. Police Court Counsel. My name is Dave Lowry. I represent Mother in this case, the appellee. I'm not going to spend a lot of time. I think my brief sets forth my arguments. I just touched briefly on the issue of the attachments of the documents. Appellant argues that the judgment is, or the entry is deficient because it didn't attach the Stark County parenting time and or the child support worksheet to the actual order that was rendered by the judge. I note initially that those were not raised as part of the objections, so the court's review of those particular items is based upon a plain error standard. Plain error has been defined quite often, Goldfuss versus Davidson, 79 Ohio State 116. It's defined as error which affects the basic fairness, integrity, or public reputation of the judicial process, thereby challenging the legitimacy of the underlying judicial process itself. I would suggest that that is not the case here. You know,
Let me interrupt you. I apologize, but I need to interrupt you. How would they have objected if it was already attached to the magistrate's decision? It wasn't an error then.
Well, I guess that's my point. I mean, it was attached to all the orders, the magistrate's order. The court ultimately adopted the magistrate's order, and I guess that's where I was coming. The appellant doesn't argue that he doesn't know what the standard order is. He had been abiding by that standard order for approximately 4 to 5 years out of Stark County because it was appended in part of their domestic relations case. So it isn't as if the appellant's arguing, hey, I didn't know what it was. He's just saying that, hey, there's some sort of a, not a substantive error, but if anything, it's a procedure error because the standard order out of Stark County wasn't stapled to the final order, even though it was stapled to the order upon which the court relied, you know, when it adopted the magistrate's decision. I mean, you know, under appellant's theory, you know, I guess you could extend it illogically to everything. That any paper that's not attached to the final entry, even though it's in the record and in the document, it attached to orders upon which the judgment relies would need to be attached. Basically, the court would be issuing a book every time it issued an order.
So then wouldn't the judge's order where it says all prior orders, not in direct conflict with the orders herein, remain in full force and effect, cover those?
Sure. You're
They're
talking
already
about
under the order from Stark County.
all of the orders in force.
Not in direct conflict with the orders herein.
Okay, I misunderstand.
Well, there was a prior domestic relations case where the custody was determined and parenting time was determined. All we did was make a modification of parenting time.
Well, no,
Everything
because,
else is the same.
no, are you talking about in terms of attaching the parenting time order?
Yeah.
All other orders? Well, no, because that order was based upon a shared parenting plan out of Stark County. The court obviated that shared parenting plan when it granted legal custody to my client.
It changed parenting time. But were any of the other things that are in that parenting time schedule, which is what, 2 pages long, and it's got all kinds of stuff in it, changed? They weren't.
No, the parenting time schedule was just visitation.
Right.
So you're suggesting that the shared parenting plan continued?
I'm saying that whatever they had, as far as parenting time,
Okay.
the time changed because this court changed the time.
Sure.
It also changed custody.
Yes, it did.
The custody of the mother.
Yes.
But every other thing that's in the parenting time schedule, which incorporates other things than parenting time, right?
Well, the parenting time order, there's, parenting time order addresses summer visitation,
All kinds of-
addresses the holiday visitation. It's all visitation stuff, the time parameters and that sort of thing.
Right, but it was ordered back in the domestic relations case.
Back in the domestic relations case, that court attached the Stark County Standard Parenting Order.
Right.
That's correct. So the court, though, I guess I'm not.
I guess my point is that this court isn't undoing anything that court already did, other than changing the parenting time and custody. Everything else is the same.
Well, there is nothing else.
Well, there's vacations, there's.
Well, but the court's adopting that as part of the Stark County parenting plan.
That's my point, is that all prior orders are still.
Yeah, all prior orders to the extent they're not obviated or revised.
Right.
But when the court granted the legal custody, certainly that's a change from and obviously that terminates that's got to terminate almost as a matter of law any shared parenting plan that was in existence because it was modification and change of custody, which leads me, I guess, my argument with those others, it'd be plain error. I mean, the fact that they're attached to the prior documents, I think, incorporated and I think satisfies those. And I've cited some cases that are specifically to that point. I've also cited some cases that are specifically to point, I believe, in terms of the argument that the non-pro-tunc order was inappropriate, and I won't, but I cited a case that I think is exactly to point on that issue in my brief. And I would suggest that also, if you take a look at the file, there was indeed a motion actually filed by my client for clarification on this issue before the appeal was filed, and it is up in the record. So there was a motion or a request filed before the appeal was filed, and I think that that's of importance, and you can see that if you review the record. In terms of the other issues, I guess I wanted to spend my time predominantly on the other issue of whether or not the court had to make a finding of best interest. And I guess in essence is the court determined under 2151 that there was no obligation to find or a change in circumstances. There was no obligation to change in circumstances. And I agree wholeheartedly. Once there's a finding of dependency at that point in time, the issue then goes towards best interest. And the court then did consider all the statutory factors that were required of the court in order to make that determination. In fact, she goes through the facts of the case, and the facts of this case certainly support, in my opinion, that she considered all the statutory requirements and made a decision in best interest. Interestingly, parenthetically, at the bottom of page 1 or 2, she does make a finding that even if best interests or a change in circumstances were required, the court's perception is that the finding of dependency would constitute a change in circumstance. And I think that that sort of ties into the fact that once the dependency more or less inherently presupposes or assumes that there's been a change in circumstances. Otherwise, there wouldn't be a dependency statute. If you go back and take a look at the magistrate's order from that dependency finding, it's clear that everything that was upon which the court relied to establish a dependency was father's behavior, and there was no behavior there that involved mother whatsoever.
I think Father's argument on that issue is, sure, we all may be on the same page on that, but there was not a finding in this order relative to change in circumstances. Just saying that if I do have to look at change in circumstances, there is a finding of dependency, I think it's Father's argument that's not enough. So I'm not agreeing or disagreeing with that, but that's, I think, where it's lying.
I understand, but I don't think that's what 2151 said. I think that the statute says if there's a finding of dependency, the court can go on and make such orders deemed appropriate based upon the best interest. The language is clear. And I also think the court, as I argued in a brief in the initial objections, I also think that the court could have made the exact same finding under Title 31. And if you take a look at 31, and it's cited there, but it's 2D. Actually, subsection C, the statute says the court may terminate a prior final shared parenting plan that includes a plan that was approved upon the motion or request of either parties, or whenever it determines the shared parenting is not in the best interest of the child. So, and that was my argument of who's for. I think that the same result, quite frankly, could be achieved in this case, because the court has the inherent power to, the court has to approve a shared parenting plan. I mean, it's not a given. I mean, you have to proffer a shared parenting plan. The court has to make a determination at some point in time, and I included all my entries, that the courts reviewed the shared parenting plan, they find it to be in the best interest of the child, they hereby adopt, same in the best interest of the child. The statute allows the court to terminate that same shared parenting plan if they make a finding that it's not in the best interest of the child. The statute has absolutely no language that says in here that, and that's based upon on findings and that sort of thing. There's no indication or language in the statute that says, well, the court can terminate a shared parenting plan on its own motion if it finds that there's a change in circumstances or that it's in the best interest of the child. The statute's plain on its face. The court can do the same thing that this court did under this statute or under 2151, which is what the court elected to proceed under.
I don't mean to belabor the point, and Mr. Eckerdwall can correct me if I'm wrong on what he's arguing. I think he may be able to agree that the court can. I think the argument is here, when you look at the entry, the court did not.
Did not what?
Did not do what it was otherwise able to do on making the finding regarding the change in circumstance. And he said, and I believe his argument is that's defective. That means that the court didn't do what they were supposed to do. Because even though it's in everybody's comprehension of how this all came to be, it wasn't in the order. It would be like on an adjudication if you made a finding of dependency, but failed to make a finding regarding the fact pattern of dependency as to why the child is dependent. And that may be, and depending on what the order says, defective. So I think his argument is, yes, I maybe can agree the court could have done this, and that what he did was in the best interest. It's just that when I look at the entry, I see that this specific finding was not made.
Well, it didn't have to be made, so what difference does it make?
I
mean, I guess that's my point, is that
He's not
I know
arguing with you, counsel.
No, I understand. I understand his point, but I know, trust me, I understand what he's arguing. And my argument is that there was no reason for it. The court parenthetically noted it for some reason or the other, but no, I understand what his point is.
To understand what your argument is, the parenthetical notation to that is not a fact of consequence at all in this case.
I think it's surplus language that I don't think that would obviate the finding that the court rendered. You can take it out, it doesn't matter. I'm just saying that, the court is saying, why she said that or didn't say that, I don't know, but I think that the result is appropriate, that the test is best interest.
So you're saying once there is an adjudication, a finding of dependency, then you didn't have to look at any domestic relations statutes, it's just within the jurisdiction of a juvenile court, it doesn't matter.
That's what I'm saying. That it then becomes a situation of what the court deems to be in the best interest. Now, I think the court obviously alludes to the statutory factors that are required to make a finding, much the same as anybody would if it was just a motion for custody or a motion to modify custody, and the court did look at all those statutory factors. The court went through the statutory factors and says quite succinctly on page 5 that based upon the in-depth review and consideration of all relevant factors, including those specifically enumerated under 2151-414-D1 and 3904-F1, which is the laundry list of items, then the court says, listen, we've considered all those and here's our decision. So with that said, thank you for your time.
Counsel, you have 5 minutes remaining.
Thank you, Your Honor. May it please the court. Concerning the objections, mother is arguing father did not object properly and that this has to be referred for plain error because he didn't object before the trial court. The magistrate did it correctly. We are not filing objections that the magistrate did not include the calculation for child support or the Stark County, because she did include it. So why would I object saying, well, the magistrate is screwing that up when...
I will say though, counsel, it gets a little confusing when in your assignment of error it says committed reversal of plain error. That seems to me like you're saying that you had to object.
Well,
when you say plain error.
I've made arguments where if you don't raise plain error, and I don't raise an assignment as plain error, if we find there was no objection. I'm doing it to cover all my bases. But I can't object to a judge's final ruling to that judge. My only option is to file a direct appeal, which I did. So if the magistrate did it correctly, but we're arguing the judge did it incorrectly, the first opportunity to raise that as an assignment of error is before this court. So I think it's a red herring to say, well, you should have raised it before the trial court. At which point could I raise it? Because the only thing I can raise to the judge is what the magistrate did wrong, not to what the judge did wrong, because the judge had initiated a final ruling. Now, concerning the fourth assignment, the father or mother is now saying that best interest under 2151-353 is the only applicability, and the judge got it right. However, again, on 810, that's not what the mother argued to the trial court. The trial court said the court should consider 3109.04E2. Father is saying you should consider E1. And the judge basically said, I'm putting a pox on both your arguments, and I'm not going to consider either one of those, because I'm only going to consider the best interest under 353. Now, she specifically said that. I am not going to consider E1 or E2 under 3109.04, which again, the Ohio Supreme Court itself said that you must do so once there is a prior allocation. Now, specifically on page 11 of my brief, I'm reading in repolling. It says the juvenile court must do so, a disposition in compliance with 2151.23F1, which states that juvenile court shall exercise its jurisdiction in child custody matters in accordance with 3109.04. And again, this court has already previously said it. Now, I know Justice Hensel was asking a question about, or I think the state was, or mother's arguing, what difference does it make? We would have won in either case. Well, I completely disagree with that, because if the judge is saying, I'm not going to consider the applicable law, and then she issues a ruling, I have no way of saying what her findings would have been if she did comply with the law. She may have not ruled this way. And in fact, I cite, in repolling, I cite on page 12 a very important paragraph from that court. It says, we would caution the juvenile court in a finding of abuse dependency alone, the court may not stand alone be sufficient to warrant a modification of custody. 2151 does not envision a scenario in which a non-custodial parent may seek to relitigate an adverse custody determination. This chapter provides a means by which the state may temporarily intervene in the family environment on behalf of the children when such intervention is mandated.
Does it give you pause that refers to a non-custodial parent, and when your two parents came, neither one was non-custodial because it was shared parenting? In other words, your client was not non-custodial when he's making this argument.
Right. He was the custodial parent, which that further supports my argument, Your Honor, that the court has to consider 3109.04E. And here, when the trial court says, I am not going to consider that statute, I think that's the fact.
So your argument is once this case is closed, you got to go back to what Stark County had to begin with?
No.
No, it says temporary intervention.
Well, it says that it depends on the fact-by-case basis. It also says that, Your Honor. So I'm not saying the court could not have done what it did, but agreeing with Justice Hensel, it didn't do what it's supposed to have done. If the judge is going to do this...
What? Don't agree with me.
I mean, in your question.
I'm trying to understand all the arguments.
I understand, but I mean, you're asking if I agreed with that.
It's fine.
I do agree with that proposition. I am saying
Okay.
the court could have done what it did, but it did not do what it was supposed to have done. And if the court said, I did consider those factors, and I still rule in favor of the mother, I would not be here on this assignment of error, because she followed the applicable law. But if you don't follow the applicable law, and you get to a decision, that doesn't make it just, because she might have reached it anyways. So if there's no further questions, I would ask the court to reverse and remand. Thank you.
Thank you both for coming in and arguing today, presenting oral arguments to the court. We will take the matter under advisement, issue a written decision, which will mail to both sides, as well as
Thank you.
Thank you.
We are adjourned.